Today, we are cracking open the rulebook for the entire planet. We're going to answer a really fundamental question. When countries are in a legal fight, where do the rules they're arguing over actually come from? I mean, think about it. If two countries have a serious beef, they can't just call 911. They need a referee, for sure, but they also need a shared set of rules to play by. So the real question is, in a world full of independent nations, who even gets to write that rulebook? Well, that's where this place comes in. This is the International Court of Justice. You'll hear it called the ICJ. You can basically think of it as the world's highest court. It's the main stage where legal battles between countries play out. Okay, but that brings us right to the core mystery we're tackling today. When those judges in their robes at the ICJ sit down to hear a case, what are they looking at? What rulebook are they actually using to make these huge decisions? Well, if you want the official answer, it's actually written down in a very specific place. It's called Article 38 of the court's own founding document. For any international lawyer, this is square one. And here it is. Article 38 basically lays out the recipe for international law. It tells judges, look, you're going to apply three main things: international conventions, international custom, and the general principles of law. This is our blueprint. Now, these are what we call the primary sources of law. This is a judge's absolute first stop when they're trying to figure out a case. So let's break down what each of these actually means. And there's a pretty clear order to it. You can think of it like a checklist. A judge will first look for a treaty that applies. If there's no treaty, they'll check for an established custom. And if that's still not clear, they can turn to these general principles. So let's start at the top. All right, first up, international treaties. You'll also hear them called conventions. Honestly, the easiest way to think about these is just like contracts, but for countries. They are written agreements where states clearly and explicitly agree to be bound by a set of rules. Sometimes it's just between two states, and sometimes it's a massive multilateral agreement like the UN Charter itself. Okay, next on the list is international custom. And this one's a little trickier because it has two key ingredients. The first is state practice. That's just what countries consistently do over time. But that's not enough. You also need the second ingredient, which has a fancy Latin name, opinio juris. All that means is the belief that they're doing this thing because the law requires them to. Here's a simple way to think about it. Rolling out a red carpet for a visiting president is a nice custom, right? It's practice. But respecting their diplomatic immunity, that's not just polite. Countries believe they are legally obligated to do it. That's opinio juris. So what happens when there's no treaty on the subject and there's no clear custom to point to? That's where general principles of law come in. You can think of these as a safety net or a gap filler. Judges can look at legal principles that are so common, they show up in pretty much every domestic legal system around the world. An idea like acting in good faith, for example. So, beyond those three primary sources, Article 38 also gives judges a couple of, let's call them helpful hints. Now, these aren't sources of law themselves, but they are super important tools for figuring out what the law actually is. These are judicial decisions, so past court cases, and the writings of the most highly respected legal experts. Now, here's a really key distinction. An ICJ decision is technically only binding on the two countries in that specific case. But in reality, the reasoning in that decision creates a powerful ripple effect, and it can influence how courts rule for decades. The same goes for the work of top scholars. Their writings can literally shape how an entire generation of lawyers and judges understands a particular law. So that's the classic picture, right? Treaties, custom, principles. But here's the big reveal. The whole thing was written a long, long time ago in a very different world. And that raises a really important question. Is this rulebook kind of outdated? I mean, just take a closer look at the original text itself. It talks about principles recognized by civilized nations. Yikes. That language is a direct product of the colonial era in the early 20th century, and it sounds incredibly jarring today, doesn't it? And just look at the timeline. This text was first drafted way back in the 1920s. Then, in 1945, it was pretty much copied and pasted for the brand new United Nations, which only had about 50 members. Today, the UN has almost 200 member states. The world is a fundamentally different place. So, is the law just frozen in the past? Well, not exactly. Even the court itself gets this. In fact, a former president of the ICJ actually praised the court for its high degree of creativity in, stretching and reinterpreting these old categories to make them fit our modern world. And because of that creativity, new unofficial sources have started to pop up. Things like soft law. A great example is the Universal Declaration of Human Rights. Now, that's not a binding treaty, but it carries immense moral and political weight, and it can create real legal expectations. The same goes for things like a public promise made by a single country to the whole world. And then there's this incredibly powerful concept called jus cogens. You can think of these as supernorms. These are the fundamental, absolutely unbreakable rules of the international community that sit above everything else. No state, no treaty, no custom can ever violate them. So what kind of rules are we talking about here? We are talking about the prohibition of the most serious crimes imaginable: the ban on genocide, the ban on slavery, the ban on torture, the ban on starting aggressive wars. These rules are so fundamental to our idea of humanity that they are completely non-negotiable. So, after all that, what does this tell us about the future of our global rulebook? Here's the most important takeaway. International law is not some dusty, static code that's been sitting on a shelf since the 1920s. It's a living, breathing, dynamic system, and it's evolving every single day through how courts interpret it, and, most importantly, through what countries actually do and believe. And that leaves us with one final, massive question for our time. As we face these totally new challenges, things like artificial intelligence, global climate change, cyber warfare, things the original writers of Article 38 could never have even dreamed of, what will be, and maybe more importantly, what should be, the next source of international law?